So I'm not here to be an advocate or cheerleader for Mr. Rittenhouse, but I'm just trying to tell the truth and tell you why this case is probably going to go the way we think it is. Hey, can you hear me?
I can hear you just fine. How's it going, bud?
I'm doing well, thanks. How are you? Sorry, I'm not on my computer, so the mic quality might not be so great.
No, it's all good. So God, I have so many fucking questions about this, but just overall, like, what do you think of the case as it's happened so far?
Yeah, sure. So I'm going to disappoint you and say, unfortunately, haven't been able to see the whole trial. Some people in my Discord have been able to follow it very, very closely and have been discussing it. But I will say, from what I have observed, the trial has not gone very well for the prosecution at all. And my global take from the little I've seen has been the following: that I don't think it's necessarily bad prosecutorial litigation or bad judge or biased judge kind of rulings. I think it's bad facts and bad law for the prosecution. And this is a hard case. Now, there have been certain moments, I think, where the prosecution has stepped over the line multiple times and has really sort of invited the ire of the judge. But that, I think, is a risk that they have to take because this case is not going well for them. And,
yeah, that's saying the least. Holy shit.
Yeah. I thought someone told me you had some questions about case law or something. So
that was one. Yeah. So I was just like writing down just in case I forgot any of the points. So I think ultimately, just based off of the way that the whole thing has gone thus far, it really does feel to me like the case is going to end, I guess, either in a mistrial, which is another question I have, but or it's going to end in him walking on self-defense grounds, right?
Yeah.
Which, like, love it or hate it, that's probably what happened, at least in my opinion. My worry is the thing that I really don't like that comes out of this is I'm worried that it will embolden militias in the United States. Could this possibly provide any case law that might be used to defend like bad actors from militias that go to fucking protests that actually do have that intent behind them? Or
I'm not worried about that, really. And I'm not worried about that for a couple of reasons. One of which, by the way, though I passed the bar, I don't want to represent myself,
of course,
just yet as a lawyer, and certainly not one who will be barred in Wisconsin. And so this is all sort of pop legal analysis. Don't take it too seriously, folks who are watching. But I don't think that there's much danger of like a bad precedent being set from a legal perspective from this case. Why? Because one, I don't think that there have been any groundbreaking or even notable changes or decisions as a matter of law made in this case. This is a fairly standard application. Now, it's not standard in the context. It's not standard in what this case means for a lot of people all over the country. And the media attention, obviously, that makes it not standard. But the application of the standard, I think, is fairly uncontroversial. What that standard is somewhat uncontroversial, at least in Wisconsin. And so I don't think that there's any groundbreaking legal thing that will arise from this case. If there was such a thing, you would have seen that probably prior to trial, maybe in some kind of or in some fights about what the jury instructions are going to be or something like that. But there's really not a big dispute about the legal standard here. And also, this is a trial court. And so this court does not have the power to set sort of binding appellate appellate precedent on any or by another court. So even if this court had said something like self-defense, you can apply self-defense whether or not you're in fear for your life or serious bodily injury. It only matters if you're in fear of a little bit of contact. Like, that would be crazy, right? But even if that was some legal standard that the judge had invented, it wouldn't be binding precedent in Wisconsin or indeed the rest of the country. So because there's kind of two answers here. One is this court can't set binding precedent to the whole state or indeed the whole country. That's number one. And number two is there's nothing really groundbreaking as a legal matter in this case, in terms of the standard of self-defense. So that's my answer there.
Okay, cool. So that assuages a little bit of my fears, because like ultimately the thing that I'm like mostly worried about in regards to these conversations that are going on online are people talking about like whether he had a right to be there in the first place and stuff like that. I am torn on these things, but I feel like there should be some kind of direct line of accountability and like chain of command, even if we're going to have some kind of community organized militia or group of people that want to protect property. They probably should coordinate pretty heavily or be conscripted or deputized by the by law enforcement, so that there's more accountability and there's more there's not two different entities enforcing the law when those two different entities might have different understandings of the law or interpretations. That's something that I do worry about.
So I'm hearing what you're saying, and what you're saying, I think, is a conversation to be had about the role of defense of private property, the role of militias, the roles of private enforcement of rights, and that is a legitimate conversation to have. Another legitimate conversation to have is sort of these conversations about whether or not he was right to be there in the first place, whether or not politically we agree with him. Those are all fine conversations to have. I think another worthwhile discussion. Now, I haven't had the benefit of the evidence in this case, being presented at one time to me. The ethical question about whether or not he should have left the scene of the initial of Mr. Rosenbaum's shooting. Those are questions that people will have to answer for themselves. Another question that people will have to answer in response to your first question is whether, even though it probably won't set sort of a legal precedent, whether or not this is a factual precedent. I think you mentioned in your whether it will like incentivize militias to act a certain way. As a legal matter, maybe not. Maybe as a factual matter. Maybe as a cultural matter, it might.
Yeah.
Those are all questions that are fine. But unfortunately, I think they're being conflated in both in the media and among commentators with the ultimate outcome of this case. And unfortunately, I just want to say this out loud. And I'm hoping at some point to have a conversation with Destiny about this, because the source of his controversial comment and the source of a lot of consternation about this case is this notion of deadly self-defensive property. But that's not what this case is about. This case actually is not about deadly self-defensive property. Kyle Rittenhouse himself on the stand, I heard it through his own mouth, said as much that he understood that he didn't have a right to defend property with deadly force. This was not a case about deadly self-defensive property. It was a case about deadly self-defense to save one's life. And these conversations about property and about the role of militias in defending that property as a purely factual, logical matter do not map on to the ultimate question of the self-defense issue in this case. And that, unfortunately, I think it's being used as such. And in that way, I think it can be confused rather than illuminate those conversations. To say nothing of something we haven't touched upon is the racial connotations to what's going on here, and the feeling of sort of double standards in our justice system that's pervasive here. And so all these conversations are relevant, but I do want to take the time to compartmentalize them and to notice that they're not precisely the same question, though it's not a waste of time to consider them.
Yeah, no, I don't disagree with that. which is why I keep on saying, like, people shouldn't be mad about the outcome of this trial necessarily, right? What they should be mad about is the militia culture that kind of made this case happen. They should be mad about so many extant things, right? I keep on telling people, and they think I'm defending Rittenhouse because I don't know, and I don't really care if he's a good dude, right? I would probably say that he's probably kind of an asshole if he's the kind of person that wants to LARP with a fucking militia group, but I don't fucking know that, right? What they should be mad about are all of those things. So
Yeah, I will just say in this moment, I hear you.
mm,
I am, and certainly I don't have sympathy for people who are for Trump supporters, for one. I don't have sympathy oftentimes for people. I don't think it was a good ethical decision to bring a gun in the first place.
mhm.
I think that just rose the stakes for everyone involved there, in a way that's kind of hard to justify, though it might be. The only problem is we cannot let our opinions on his presence in the first place, his political beliefs, his possession of a weapon. We cannot let that blind us in a way that I'm sorry to say, and I hate to, because it's almost cliche at this point to start talking about the media's coverage of this and
Yeah, of
blaming.
course.
I'm very often a defender of the media in the United States, and I'm a defender of journalism, but I think they've really dropped the ball in some of these conversations about what's going on here, and
Yeah, it's like on one side, Kyle is a fucking hero, and on the other side, Kyle is a neo-Nazi fucking that went out to fucking hunt black people around Kenosha, but that's just not the case, right? And it's fucking wild, and these are major news publications. Right. I've been staying away from major news publications on this because I don't feel like I could trust even like CNN or New York Times or certainly not Fox News. Like, these are places I would normally go to find information from one slant or another. But yeah, this is too much.
It's hurtful to see this because I really do think I'm a defender often of the quote unquote mainstream media.
Yeah, same.
But in some capacity, I suppose. But the accusation that the political alignment switched here, people would be treated differently. I think that it's hard to deny that alternative universe, and for me to be like, okay, suppose that it were the other way around, and this were, the Black Lives Matter individuals defending themselves. For me, I think I would see a total flip the script in terms of the who's defending which position, and that to me is an indicate. Except for some people who you can say are consistent in how they apply this, that can't be correct. That we cannot allow our political leanings to influence the application of a self-defense standard that ought to be indifferent to those considerations. So I'm sensitive to that criticism, and I'm a little bit. I don't know how to respond to that, and I think I've been put in a tricky situation of ultimately having to defend a media that's been under attack and under assault by a lot of forces, both on the right and left. But that, in my mind, in many ways, is dropping the ball here, and also setting expectations which can't be met, and doing a disservice to the public conversation sometimes.
Yeah, I think it's really tricky if you usually defend mainstream media, because this is really playing into the right-wing narrative that it's always biased against the right and blah blah blah. And it's like, in this case, I can't really argue against that, but it's I would have to look at more of the headlines and actually see if the articles themselves are as biased as the headlines would make me think. It's really it's a really unfortunate position for us to be in. So one big thing that I keep on I genuinely don't know to what degree the judge has a like leeway on how he acts or reacts on this I was about to say the stand, or whatever they call what he sits in, right? When there's like just been multiple times in just the 2 days that I've been watching, right? It seems like um he's fairly aggro towards the prosecution and very sympathetic towards the defense, right? I don't know if it's to the point where I would say, because I don't know how much of it or to what degree it's been going on the entire time, but
Yeah, no, I'd love to comment on that. I mean
that
because that is an observation that I'm seeing about the judge. Listen, I don't know anything about this judge's background, or apparently he's made some like weird jokes or something. I don't know about those either. But on the matters that really got him angry, I'm not well versed in these evidentiary issues, such that I feel confident to say that I know every contour of it, but I know enough to say that I probably agree with the judge on his attitude to the prosecutor, and I'll tell you why.
yeah,
At least in those, and so yesterday, I think it was yesterday, maybe the day before, there were kind of like two big moments of questioning where judge got super mad. One was, as you know, in this country, there's a right to remain silent, which is a very important right for Americans. And one of the ways that manifests is there are only limited ways in which you can comment on people's silence at trial. Typically, like after you've been arrested, after you've been Mirandized and stuff, that's like a pivotal moment in time where the prosecution can't like comment on your silence as to be like, look, he didn't say anything to us, therefore he's guilty. Because like, what does the right to remain silent mean if you have the
right to do that, but they don't, but they like are pointing towards that as some form of evidence. Yeah, yes. Of course.
And so, but you can use it maybe in other ways. Let's say that you were, before you were indicted, someone like said, you murdered Kelly, a private citizen said that, right? And you say nothing in a situation in which a normal person would deny those things. Right. And then that person comes out to testify that you said nothing in that moment. That might be a situation in which like your silence actually can be used against you, that like he didn't say he didn't reject it, he didn't deny it. That same kind of thing couldn't be allowed after you've been sort of indicted, arrested. So there are ways in which silence can be used. Obviously, you can waive your right to remain silent, in which case, things are more fair game for you. But what the prosecutor wanted to do, this is the first incident, was like comment on his silence, not just his silence like before he was arrested, but like his silence for months and months and months and months. Now, actually, there is, I think, some dispute about whether he waived his right to remain silent. So that might be, an active dispute about it. He talked like some reporters or something. But if he didn't waive it, that's a huge issue for the prosecutor to like start to comment that you didn't say anything beforehand. That's commenting on his silence. And what the judge said is that that's a constitutional violation. I think he maybe equivocated a little bit and said, you may be crossing the line. I think he said something like that, but that's serious stuff. And, and if the shoe were on the other foot and it was like, a left-wing person, I'd be really, really mad. And so I understand why unless he in fact waived it, and that's a thing up for dispute. But if he didn't really waive it, if I was the defense, I would be super mad too. Super mad.
Is taking the stand waiving your right?
So you are allowed to be impeached and cross-examined when you take the stand, but that doesn't mean that you can then comment on your silence before you took the stand, kind of deal. So taking the stand itself, as I understand it, and someone please correct me if I'm wrong, would not be a waiver of all of your post-arrest silence. It wouldn't. His mere testifying shouldn't open the door for the prosecutor to comment on his silence before the fact. That's my understanding of it. I could be wrong about that, but I'm fairly sure that's correct, or at least maybe there's an exception I'm not thinking about. But the judge was very harsh in that respect. That's number one issue. But the number two issue for which he really, really got mad was an evidentiary issue related.
Is this the pixels?
No, this is an issue actually with a prior statement I think made online. It might have been like a Facebook post or something on social media to the effect of where Kyle Rittenhouse said like, I wish I had my AR-15.
Oh yeah, someone showed me that earlier today, and I had not heard that whatsoever.
Yeah. So he had made that statement, and the question is like, what evidence in a case must be relevant. You can't offer irrelevant evidence in the case. And so the question becomes, why is that statement relevant? The key issue in this case is kind of like Rittenhouse's state of mind. Was he actually in fear for his life? Or the prosecution wants to paint him more as like some gun-ho kid who was looking for a fight and got one. Yeah. That's kind of how they want to paint him. And so his state of mind is very much relevant, and very so like there are big fights before the trial even starts on like things called motions in limine, or like motions to suppress, that kind of stuff, which is all about kind of like evidentiary issues. What's going to be allowed and what's not. What's too prejudicial, what's probative, what's irrelevant. And the judge apparently had made some preliminary ruling directly, although the prosecutor says like, you left the door open that you might change your ruling. So there's a little bit of dispute about like whether or not he had forbid this evidence. Mm-hmm. But the logic of forbidding the evidence is the following. What Kyle Rittenhouse said on his Facebook post, you trying to introduce that as evidence, I think weeks or months. It might, I
thought that the evidence that they tried to put forward was a video 2 weeks prior of people that he assumed were stealing from a CVS and saying that he wished he had an AR-15 because he would be, I think he said he would be firing shots at them. Yeah.
So the question is, why is that relevant to his state of mind on the day in question? His state of mind on this is not a trial to see if Rittenhouse is a bad guy. It's not a trial to see if Rittenhouse is an asshole or if Rittenhouse is whatever. That's the kind of evidence of, it's kind of like character evidence that you're trying to introduce to show that he has a propensity for a particular state of mind. Now that kind of evidence, there are some places in which it's allowed. This kind of evidence where like you're trying to give evidence of a prior bad act or a prior wrongdoing or a prior misspeaking, right? That evidence might be allowed because typically it's going to be just because you did a crime in the past or just because you said something racist in the past or you said something whatever in the past doesn't mean that you're going to be a criminal now, or you're going to do a wrong thing now, or you're going to say a wrong thing now. And we're actually very fearful of letting that evidence in. Like we don't just let people say, well, he beat me up before. Let's say someone like is being accused of like robbing a liquor store. We don't just let some random person who's been beat up by this guy before just be like, well, he beat me up 2 weeks ago and therefore he has a bad attitude and he has a propensity for criminality. Like that is super prejudicial, and we try to keep that out. The only times when we're going to let that in is like if it's very, very probative. It's very, very probative. It's like, okay, this is such a specific act or statement that it shows what his identity is, or it shows some kind of common a common plan or a common scheme. So there's like particular areas in which you're allowed to get this evidence of prior bad acts or prior bad statements in that like weren't covered by what the judge was saying, or what the weren't covered by in the judge's interpretation of the situation before him. What the judge said is that there's no analogy. This is a comment made like 2 weeks before the incident in question when he doesn't have a gun. And that's totally different than, say, for instance, Rosenbaum saying, I'm going to kill you in the moment, is different than someone making a colorful comment 2 weeks before. That there's no analogy here. So that's kind of, and so he ruled that you're not allowed to bring that up. And then he brings it up.
My question would be, why would, so the thought process that I would assume that they went through would be that, okay, so he obviously has a certain feeling towards people who he thinks are robbing or looting. He has the desire to, or at least has outwardly expressed that he wants to shoot people that are doing those things, right? I don't understand how that wouldn't be directly related to the case of him getting a gun, going to a protest to defend property from being burned or looted, right?
So let me give you an example of how this might be applied in a way that you don't like. Suppose you have somebody who's on trial, we'll say we'll do the robbing the liquor store example. And you have evidence that he robbed a liquor store 2 years ago. Do you think that you should be able to introduce that evidence to prove that he's guilty of this crime because he did it before?
Sure. I don't think that would be relevant, but I would say there's a certain time frame in which you can make a statement that I think would be relevant, right? I don't know exactly what that. Yeah. I don't know what that line would be, but 2 weeks is not like nearly that that long, and also given the climate of what was going on right then with the BLM protests, right? And I don't know about what the Facebook posts were, but if those were also similar in nature, right? I think that you could
potentially a closer
case,
call. Yeah, I think my example is I was really trying to show you when you would think it's really bad, to show you why this rule is in place. This one is probably a closer call. I would probably agree with you. But I think it's the totality of what's going on that's informing the judge's opinion. The judge is saying he didn't have a gun at that moment, and it was in a context in which tensions weren't as high, let's say. And so he's trying to make this analogies to that situation and this situation, and saying, really, there are moments where people might say, I'm going to kill you. And that's like classic protected political speech, and where it's not going to be used against you necessarily if it's interpreted in that context. And I think I don't know if you guys ever seen 12 Angry Men, those of you in chat, it's a very famous movie. But there's sort of a famous part where he had been heard by someone, a neighbor, the person on trial, saying, I'm going to kill you, to the decedent, to the father. This is the person on trial. And that was used, that sort of the prosecution made a lot of that statement. And then in the actual deliberation room, the jurors, the tension start getting risen and all that stuff. And one of the jurors is like, oh, give him over here. I'll kill him. And I forget who, it might have been Jane Fonda's father. Is it Henry Fonda? I'm not sure. Said something like, you don't really mean you're going to kill me. And that's the kind of the feeling of what's going on here. Is that in different contexts, if the situations are dissimilar, we don't just want to introduce evidence that he's a bad guy or that he has a violent temper, because we don't trust that stuff. And we think that it's, unless it's super probative, by showing some identity, showing some specific mental state of mind that's probative to the specific situation, we're going to be very skeptical of that evidence. I will say it's probably a closer call than the example I gave of the 2-year time gap.
Sure.
But that's really not the call. It could go either way, and different judges, reasonable minds may disagree on that. That's just the basis of what I'm explaining to you.
Yeah,
the problem is the judge made that ruling, and having made that ruling, you can't
bring it up.
then
Yeah. No, I understand. Yeah.
right. That was the problem in the prosecution. Let's say the defense was totally, or sorry, the judge was totally wrong about that decision. Okay, he's wrong about it. You had the fight about it. You lost, and you have to move on. And you trying to shoehorn excluded evidence, that would piss me off if I was the opposing party. And frankly, I think unless I'm getting some of the facts wrong about the issue here, and maybe I am, but if it is as I think it is, I would be really mad if I was the defense too. And if I was a judge, I'd be mad too. We just spend like weeks researching this issue, arguing this issue, and then all of a sudden you just decide to bring it up to the jury. Like, that can't be allowed, and you're going to get admonished. And I think that's what happened. Whether or not it was appropriate for the judge to do that, judges yell sometimes. And frankly, just based on what I've seen of that, I don't think he was that out of line, to be fair. And I think I would be equally mad if I was the other side.
Yeah, no, I would understand why the other side would be upset about that. I also, one part that really stuck with me from yesterday was the argument around like zooming into a picture and the judge's seeming lack of technical knowledge, leading him to kind of lash out at the prosecution. I just didn't know if like the judge normally lashed out in cases where like I didn't know if that was something that happened often in court, or if it was something that was allowed in court normally or something like that, or if it was acceptable. Yeah,
the court, it really depends on the court. What you're talking about is that the judge, what I think you're talking about is there was a similar problem with the evidence presented by the defense, or something like, or there was some problem with certain evidence, and it wasn't objected to, and it was objected to by the other party. I think the defense objected to the prosecution's use of it, but not to their own use of it.
Yeah.
And the judge's like, well, you didn't object. And there are certain things I think that the court can sua sponte, can on its own initiative, on its own accord, it might sort of raise an objection or stop something if it doesn't like something. But really, what we know from the American system is that the lawyers are the drivers of the criminal litigation. That's the goal. And judges are loath to interfere in that. This is all just normally, right? And the judges are really going to let you drive what's going on. And if you fail to object, I'm sorry. Like, that's why you got to be on your game. You got to be prepared. There might be times where you tactically don't object to things that you could probably exclude, but maybe you want them to open the door, or you think it actually looks bad for them. But if you don't object, you don't object. And it looks like they might have been caught with their pants down because they used some technique that they didn't have an expert witness to explain or something like that. Which, again, I didn't see that whole exchange, but I don't know that there was a big break-in procedure for the judge acknowledging one objection, notwithstanding the fact that there were similar problems in the sort of previous use of evidence. I will say, like, suppose that someone does a leading question on direct examination and you miss it and you don't object to it. Does that mean that then the next party gets to just ask leading questions on direct as much as they want? No, like, objections are there for a reason. If you fail to object, usually you're out of luck.
Okay. Well, I guess like the last thing, because I guess like two things. You said bad facts and bad law, but like, do all of these things combined lead you to think that this could end in mistrial? And what does that mean?
When I say bad facts and bad law, I mean that the defense is a good case. And the defense is a good case because reality is good for them.
Yeah.
Reality of the factual circumstances and reality of legal doctrines that we use. It's just good for them. Now, we can pretend that's not the case, but it is the case. And whether the question about the mistrial is not so much about the bad facts. The question about the mistrial is the stuff we just talked about relating to the right to remain silent and like the evidentiary stuff. That's kind of the basis of the motion for the mistrial, from what I know, from what I believe. I could be wrong about that, but I think the basis is like those stuff like that. The bad facts and bad law relate to why this case was an uphill climb from the beginning. And it was an uphill climb from the beginning because of a lot of stuff, but like everything was hard for the prosecution. I mean, you essentially, I don't think a lot of this evidence was included, but even facts about the decedents was not good, right? Because the people who had like sexual impropriety or sexual offender charges or whatever, or they were convicted sex offenders, or they were like ex-felons. Someone was pointing a gun at oh my God, Rittenhouse. Mm-hmm. And like, so all that stuff combined, all the window dressing for the most part is bad for the prosecution. And the substantive evidence is bad for them too, because he did go for his gun, you know, from what I saw. I think Rosenbaum. And the other guy, I think, did too.
Well, Rosenbaum didn't point a gun. He was just charging.
Not Rosenbaum.
Yeah,
sorry,
the
Rosenbaum
other guy.
was charging on him.
Yeah.
But it is true that Rosenbaum was chasing him. That is true, right?
Yeah.
And he wasn't stopping. It is true that I forget the other guy's name, who grabbed his gun at some point. Mm-hmm. It is true that Kyle Rittenhouse was hit multiple times. From what I don't know if there's video of that, but I don't think that that's disputed. Maybe it should be disputed. I'm not sure, but I'm going to assume for now that Rittenhouse is telling the truth about that. It is true that that third guy pointed a gun at him. Apparently he admitted to it. And I'm sorry, but those facts make out probably a reasonable fear in the mind of a reasonably prudent person that your life or serious bodily injury, you know, is in danger. That's just the law. And, you know, if you say you wish it were otherwise, you have to ask yourself seriously, like, what law would you prefer? Now, I take very seriously the ethical decision for Rittenhouse to be there in the first place. I don't think it's trifling to ask that question. Mm-hmm. I don't. You examine actions by human beings to see if they were ethical. And it's not relevant necessarily to the question of self-defense as a legal matter. As an ethical matter, it certainly is relevant. And I would condemn in the harshest terms his presence. And it doesn't make me a hypocrite, because I could just as easily condemn the burning of private businesses, and I'm not a hypocrite. And I could potentially condemn, though I haven't made a decision at this point, Rittenhouse's decision to leave the scene after the first shooting, and potentially in so doing, I haven't made my mind up because I haven't seen all the evidence, potentially endanger the lives of others by running away from the scene. But those ethical questions, for the most part, are ethical questions, and I don't know that they're relevant to the legal standards. So I'm not here to be an advocate or cheerleader for Mr. Rittenhouse, but I'm just trying to tell the truth and tell you why this case is probably going to go the way we think it is.
Yeah, no, for sure. And that's one thing that I had a rant at the beginning of stream about how I'm really upset with people online right now, because I started off talking about politics online from like a very, very lefty point of view, very, very socialist point of view. But in recent months, and especially recent weeks, I've gotten so fucking black-pilled on the broader online left, and especially with the way that people are talking about this case. The discourse is so fucking poisoned that any amount of trying to talk about like the realities of the case from the left is seen as a defense of Rittenhouse himself, when I can say, like, okay, like in a vacuum, in the purview of this case, he was doing self-defense, right? There's no evidence to show that he's a fucking Nazi, no evidence to show that he was like trying to hunt fucking black people, right? There's like no evidence for any of that, but there are things that we can still criticize, and we're giving up this like a layup in terms of optics to the right when we're making fun of Rittenhouse crying, not just like making fun of him crying, but saying that it was fake, or saying that the court system is white supremacist in this case, but the system is working perfectly fine when Derek Chauvin got sentenced, right? Like these are it, there are just like things that we could actually hit on to get the actual message of more, like even if you're not like a socialist, like left leaning positions out there, right, that are reality based, that would get people to like think about this. Oh, maybe he shouldn't have gone there with a bunch of people armed to the fucking teeth. Like according to him, like by his own words, I believe that he did not bring anything that was non-lethal, right? Like there's there are problems with that. There are problems with people trying to take vigilante action, even in these cases, right? And you can argue those things so much better than the everything that I see from all the stuff directly relating to Rittenhouse to, hey, we should just like be there ourselves, armed to the fucking teeth with our own fucking militias, right? Because there have been countries that have had that in some people's living memory, right? A lot of them are old, but like in 1920s, early 30s Germany, there were roving militias of fucking fascists and socialists that were fucking clashing and killing each other constantly. I don't want to fucking live in that world, right? We're in America, we don't need that sort of thing, right? But it seems like that's where people are going with it.
Yeah, I don't know what the impact will be on I don't know, the militia culture in the United States.
Yeah.
But I do think that we need to be, or people need to be smarter about their positions and more analytical and rational, and not be not buy into this war of all against all that is kind of beginning to dominate our culture. It's the same tactic, I would say, of the Trumples, who pretty much consider, if you're not on board with us 100%, get out or get off the train. And that attitude, I think, is toxic and needs to stop. But unfortunately, I really do think that people's opinions on this case are largely, not everyone, but a lot of vocal people's opinions about this case are largely tailored by the political realities of the actors involved.
Yeah.
And it shouldn't be, at least not in the sort of discrete issues of legal culpability. And those people who are saying, well, okay, legally he's probably okay, but he should still be convicted or something like that. That just makes no sense. We want a legal system which is fair and balanced and neutral to ultimate questions of, are you a good or bad person? There are a discrete set of elements to make out in a criminal indictment, and the burden is on the prosecution, and that system should be jealously guarded. And we can't just be like, oh, who cares about the right to remain silent because it's someone we don't like,
Yeah.
or who cares about the judge's evidentiary rulings because it's Rittenhouse. That's absurd. And I'm not going to be a hack myself, and I wouldn't want anyone else to be a hack or merely a cheerleader, because then you're no better than the Trumples.
Yeah, I would agree. I don't want to meet violence with violence. I think that if you have a vision for the future, you should have one that has like a foundation couched in like something positive, right? I have a positive view of the future, therefore I want to reach that in the best way possible. If you allow the anger and the hate and pain, I know it sounds super hippie, but like if you allow that to be the dominating force for your movement, you're either going to turn into someone that's like incredibly fucking violent, or your movement is going to fail because you're just going to turn everybody off to your movement. As
Yeah,
my last thing, because I have a podcast I have to do
sure.
here in a minute. And this doesn't really have anything to do with like a legal question. This is just, what do you think if Rittenhouse walks? Do you think that there's going to be like mass protests or like violence? And B, if that does happen, what do you think are like would be the fallout from that?
Yeah, so obviously I don't have any specific or useful insight into I guess the attitudes and current temperature of Kenosha, but I think it's become sort of a self-fulfilling prophecy. There are going to be riots, sorry, there's going to be protests. People are scared. They're going to be protests, and so in some sense, us talking and giving this attention, giving this case so much attention and so much energy, is in a sense almost guaranteeing in my mind that there's going to be demonstrations, as people have a right to demonstrate and to express their anger. We can think that they're ill-informed, or that they're the law doesn't agree with them, but I would respect strongly anyone's right to protest this ruling if and when it comes down. That said, it ought not to descend into violence. I would condemn that in harsh terms, and I would also defend Rittenhouse's acquittal if he is in fact acquitted, and say that ultimately, we should not just try to find a way to retry him, which is almost certainly not possible under modern constitutional law. And so I think that people, what they're likely to do is probably protest, which I respect their right to do.
Yeah, of course.
What I'm fearful of is
violence
or ugliness, and I don't want to see that.
Yeah. Well, if you have any final thoughts or anything, you're more welcome to say them. I appreciate you coming on.
Yeah, thanks for having me. I guess I'll close with a couple things. One is I've sort of seen some debate in your chat about the relevance of someone breaking the law and then trying to claim the privilege of self-defense in the process of having broken the law. There are actually like statutory and kind of legal bars to using self-defense under certain circumstances. I don't think that they're necessarily at issue in this case, because I don't know that the gun possession charge qualifies as something for which you'd relinquish self-defense. The burden of the self-defense as a privilege. Mm-hmm. I don't even know if it would shift the burden to additionally to the defendant. And I think that we would all prefer a world in which misdemeanors like that do not relinquish your right to self-defense. Certain kind of states of mind, I could understand relinquishing the privilege of self-defense. If you intended to provoke someone to attack you so that you could kill them, I think that would be a state of mind which should preclude self-defense. But I don't know if there's any evidence that Kyle was intending to provoke someone to attack him so he could kill them. That to me seems eluding. So that's just my response to kind of those questions. And thanks for having me.
Yeah, absolutely, buddy. Hope to talk to you soon. I'm getting more into legal knowledge and economics. So those are like the two things I've been hoping to get more knowledgeable on. So
yeah, it's a fun world. It's a big world. It's a complicated legal system, and I think that everyone should be more involved in it and interested in it. I'm glad that you're taking an interest in it.
Yeah. Well, I'll catch you later, buddy. All right.
See you later, man. Have a good one.
You too. I think Pisco is super fucking cool.